Hi and hello everyone. I'm an intern at Lawmates. In today's video, we will be understanding a very important concept in criminal law. That is, how does a bail work? Bail is one of the most essential safeguards in our legal system because it protects a person's liberty, dignity, constitutional rights, even when they are accused of a crime. What is bail? Bail is the temporary release of an accused person from police or judicial custody on the condition that they will appear in court whenever required. In simple terms, bail lets a person stay outside jail while their trial is going on. The aim is to ensure two things. The accused appears in court, the accused does not misuse their freedom. It is important to remember that bail is the rule, jail is the exception. This principle comes from the Supreme Court of India to protect personal liberty under Article 21 of the Constitution. Why does bail exist? Bail exists because of four reasons. Firstly, presumption of innocence. Until a person is proven guilty, they are considered innocent in the eyes of law. So, they should not be unnecessarily kept in jail. To prevent overcrowding in prisons in the second place. Most untried prisoners are waiting for their trial, not convicted. Bail helps reduce this burden. Thirdly, protection of fundamental rights. Under Article 21, every person has the right to life and personal liberty. Detention before conviction must be justified. And fourthly, fair preparation for defense. Being outside custody helps the accused prepare their case better. Types of bail. Firstly, regular bail. It is given when a person is already arrested and wants release from custody. Magistrate grants bail in bailable offences. Magistrates or Sessions Court or High Court grants bail in non-bailable offences. It is covered under Section 437 and 439 of CRPC. Anticipatory bail. This is bail in anticipation of arrest. A person who fears arrest for a non-bailable offence can apply to Sessions Court or High Court. This protects them from being taken into custody. This is covered under Section 438 of CRPC. Interim bail. Temporary bail for a short period until the court decides the final bail application. Default bail. This is covered under Section 167 Clause 2 of CRPC. If the police fail to file a charge sheet within the required time, that is 60 days for most of the offences and 90 days for serious offences, then accused gets a right to default bail. Bail in bailable and non-bailable offences. Bailable offences. The accused has the right to bail. Police must release the person on bail. Magistrate also cannot refuse bail. Non-bailable offences. Bail is not a right. It is at the discretion of the court. The court examines several factors before deciding it. How does the bail process work? If already arrested, the application for regular bail falls. If there is a fear of arrest, they can apply for anticipatory bail. Step 2 will be filing the bail application. A written application is filed in the court mentioning the facts of the case, grounds for bail, personal background of the accused, assurance of cooperation. Step 3 is court hearing. Both sides will be heard. Defense argues why bail should be granted. Prosecution argues why it should be denied. Step 4 will be court order. The judge may grant bail, deny bail, grant conditional bail with certain restrictions. Step 5 will be furnishing bail bond. The accused must sign a bond and may need sureties. Surety is that a person who takes responsibility that the accused will follow bail conditions. Conditions of bail. Courts may impose conditions like not leaving the city or country, appearing before police whenever called, not threatening witnesses, not committing similar offence, and surrendering passports, etc. Violating these conditions can lead to cancellation of bail. Factors. There are some factors that courts should consider before granting a bail. That is the nature and seriousness of offence, past criminal record, chances of accused fleeing, possibility of tampering with evidence, chances of threatening the witnesses, health, age, and personal circumstances, and whether the accused is cooperating in the investigation. When bail can be rejected. Bail may be denied when offense is extremely serious, like terrorism, murder. Strong evidence exists against the accused may be abscond, the accused may influence witnesses, they have a history of not following court orders, they are a threat to society. Important Supreme Court guidelines for bail. Bail is the rule, jail is the exception. It was stated in State of Rajasthan vs. Balchand, Husainara cartoon case, Harnish Kumar case. Bail cannot be used as a punishment. Accused is still presumed innocent. Avoid unnecessary arrest. Harnish Kumar judgment says police should not arrest casually. Conditions must be reasonable. Bail terms cannot be so harsh that the accused cannot comply. Women, sick prisoners, and elderly must be treated with leniency. It was dealt in Section 437 CRPC. Criminal justice system. Bail is one of the most personal liberty, ensures fairness, and balances the rights of both society and the accused. Bail does not mean a person is declared innocent. It simply ensures that no one loses their freedom unnecessarily before the trial is completed. I hope you understand. Thank you.